Hello and welcome to Sexual Harassment and Abusive Conduct Prevention Training. Before we begin, I'd like to remind our audience members that this is an interactive discussion, so I certainly welcome any comments or questions you may have, and feel free to type it in. I will do my very best to respond to each of your comments and questions throughout the presentation, but if I'm not able to get to them, I will certainly send you a response by way of email after the presentation. So the purpose of our discussion today, our 1 hour discussion today, is that we are going to be covering the definition of sexual harassment. We're going to look at the different kinds of categories of sexual harassment, the various elements within those definitions, and we're going to explore that through hypotheticals and examples and cases. And we're also going to answer questions such as, who are the people that are possibly involved in sexual harassment claims, and what kind of remedies could a complainant or a plaintiff recover in a sexual harassment claim? Then we're going to cast a wider net, and we're going to talk about abusive conduct in the workplace. And we're going to talk about that with regards to categories that are protected. So what are those types of abusive conduct actions that are considered unlawful with regards to certain protected categories? That's actually a great place to start. So let's talk about what those protected categories are. Okay, what am I talking about? So you'll see in our very first slide here that under California state law, as well as federal law, that there's certain protected categories. What that means is that employers are prohibited from harassing or discriminating against applicants and employees based on specific protected categories. I've listed a few of these categories here for you. So let's take a look at what these are. One of them, first, is sex. There's gender, sexual orientation, gender identity and expression, pregnancy, race, national origin, religion, age, mental or physical disability, medical condition as it relates to cancer, and military or veteran status. Now, these are not all the categories that are protected under both state and federal law, but these are the pretty common types of categories that are usually involved in many lawsuits. So for the purposes of our discussion today, we're going to be focusing on the first four categories, which is sex, gender, sexual orientation, gender identity and expression, with regards to our discussion for sexual harassment. Okay, so let's begin with that. As many of you know, there has certainly been in the last couple of years the Me Too movement, with individuals who've come forward, who have been empowered to share their particular stories involving sexual harassment, assault, and battery. But before we get to the Me Too movement, let's kind of take a step back and take a look at how we've gotten to where we are. How is sexual harassment in the United States developed over time from a national perspective? So I have a slide up here discussing some very key cases that have been in the public eye from a historical perspective involving sexual harassment. The first that I've highlighted goes back to 1991 and involves Clarence Thomas and Anita Hill. As many of you may remember, in 1991, Clarence Thomas was nominated to be on the Supreme Court of the United States. But before he got put on the Supreme Court, they had to hold a judicial nomination process before the Senate Judiciary Committee. And in that process, testimony was brought forward regarding Clarence Thomas. One of the individuals who testified was Anita Hill. Anita Hill was a former colleague of Clarence Thomas. Specifically, she reported to Clarence Thomas some years back when they both worked at the Department of Education as well as the EEOC. During the course of her testimony in the early 1990s, America was basically introduced to this concept of sexual harassment in the workplace, at least on a very national level. And what I mean by that is she testified on C-SPAN, on live TV, as to what she had experienced while working
with Clarence Thomas some years back. She felt compelled to do so because she felt that it went to his character since he was being nominated to the Supreme Court of the United States. It was then that we first started hearing about, gosh, what is the sexual harassment in the workplace? She talked about how he had propositioned her, that he had discussed different types of stories or jokes of a sexual nature. And of course, there's that reference to that infamous Coke can, where on one occasion, she alleged that he came over to her desk and said, "Who placed a pubic hair on my Coke can?" So a lot of very salacious details came out of her testimony, and America was riveted and was captivated by what exactly is sexual harassment in the workplace. Ultimately, despite her testimony, Clarence Thomas did come forward and denied all her allegations, and he was put forth in the Supreme Court of the United States, where he sits now. Let's fast forward a couple years from that to 1994, where President Bill Clinton, then President Bill Clinton, was sued by Paula Jones, who was a former employee of the government of Arkansas. Now, this is a very interesting case because at the time that it was filed, President Clinton was already a sitting president, and he was being sued for sexual harassment by Paula Jones for acts that he committed prior to taking office when he was the governor of Arkansas. And in that lawsuit, Paula Jones alleged that she had met Bill Clinton when she was an employee for the government of Arkansas, that she had been introduced at some kind of event, and that she had been escorted by a state trooper to meet Mr. Clinton at his hotel room, where, according to her, he had exposed himself to her and propositioned sexual acts. Paula Jones sued based on those facts. Mr. Clinton denied it, and ultimately that lawsuit was settled privately for approximately $750,000. So that is an important lawsuit because, again, it was very much the interest, a national interest, and it also sets the tone in terms of presidential powers, in which the Supreme Court actually made a decision that the president is not above the law and that the civil action filed against him by Paula Jones could go forward. So now that gives you a little bit of a background as to sexual harassment in the news in the early 90s and mid 90s. And now let's fast forward to just a couple years ago, where you have a tweet from an actress named Alyssa Milano, where she was empowering others to come forward and talk about whether they've been sexually assaulted or harassed by typing or tweeting "Me Too." And from that, many other celebrities were empowered, they've come forward, and there's been quite a bit of movement in terms of the Me Too movement, whether it's through marches, whether it's through different articles that have been written, different interviews that have been granted by a variety of very famous people regarding this very topic. Unfortunately, with empowerment, there's also a dark side that has been exposed in terms of some individuals who are very famous. So in 2018, the New York Times ran an article and highlighted approximately 90 individuals who have been accused of sexual harassment and sexual assault and battery, and those individuals were forced to resign or were actually fired from their positions. Okay, so I'm not going to be able to go through all those individuals, but I wanted to highlight some individuals I think that are of important to kind of discuss. Okay, so the first one you'll see on the slide here is Harvey Weinstein, and as many of you know, many women, dozens and dozens of women have actually come forward and accused Harvey Weinstein of anything from sexually inappropriate comments, acts, all the way to actual rape and assault. So Harvey Weinstein was a very famous Hollywood producer, and his company, the Weinstein Company, produced lots and lots of big blockbuster movies. And these women have come forward and accused him of a variety of different kinds of acts. There are currently some criminal charges pending against Mr. Harvey Weinstein in the state of New York, and we'll have to see how that actually plays out. The second individual here that I've highlighted is another famous individual in the acting community, Mr. Kevin Spacey. He was accused by another individual, another male individual, of actually having sexual relations with him when that particular individual was a minor. Mr. Spacey's representative have come forward and basically have just stated that Mr. Spacey is seeking time to evaluate himself and get some treatment. So there is no actual acknowledgement of what he had done or whether or not it even happened. The last individual on this list is an actress by the name of Asia Argento. She was originally one of the first women who actually came out and accused Harvey Weinstein of assault and battery, sexual assault and battery. Now, interestingly, about a year later after she came out, she found herself on this list as well because a male colleague of hers who was at the time a minor had come out and stated that they had a consensual sexual relationship when they were filming some type of project. So as you'll see, both men and women have been accused of sexual harassment. I'll quickly go through some of these. We have Donovan McNabb, who, as you know, was a very well-known football player. He was accused of propositioning and harassing colleagues when he worked for ESPN. He ultimately was terminated from that position, even though he denied the allegations. The other individual on this slide, Trent Franks, was a former congressman from the state of Arizona. He was accused by some of his female staffers of having some inappropriate discussions in the workplace regarding the struggles him and his wife were having regarding infertility. Some of the discussions even escalated as to proposition one of the female staffers to be a surrogate for him and his wife. So ultimately, he apologized and acknowledged that his comments and behavior were not appropriate for the workplace. The last individual on this list, Matt Lauer, who was a host of the Today Show on NBC for many, many years and was very respected by the journalism community. Unfortunately for Mr. Lauer, there was an allegation brought forward by a female individual who had worked for NBC, and she had claimed that he had propositioned her and continually harassed her when she was working for NBC, and also that she was forced to stay in his office and not able to leave because he had a mechanism in his desk where he could press a button and lock his office from within. This is within the NBC building. So ultimately, after NBC received that complaint, they investigated and terminated Mr. Lauer within approximately 4 days of the allegations. The last group here, we have Russell Simmons, who is, not only in the music industry, but also in the fashion industry. He was accused by multiple women of inappropriate conduct, all the way from sexual battery and assault. He too has actually denied any of these allegations and have claimed that those relationships were consensual in nature. Nevertheless, Mr. Simmons has actually stepped down from his board of directors for his company. The second individual on the slide, Cristina Garcia, is a congresswoman from the state of California. Ms. Garcia was accused of actually getting intoxicated during a company event, a government event, and groping one of her male interns. She has since apologized for that behavior and basically stated that that was inappropriate. And the last individual here is Joe Biden, who was a former vice president of the United States and is now a candidate for the presidential race in 2020. Several weeks ago, women have come out and stated that Mr. Biden engages in kind of strange, touchy-feely behavior, such as hair sniffing or being too touchy-feely or too much hugging, and it made them uncomfortable, so to speak. So Mr. Biden, what he's done, he's come out with a video, apologized, and acknowledged that perhaps that his behavior made these individuals uncomfortable, and he has provided that he is going to be more aware on how to interact with others. So that's just several examples of a variety of individuals, both men and women, in different kinds of industries, from politics to sports to the movies, right, to Congress people who have been accused of sexual harassment all the way to sexual battery and assault. And it gives you an idea that nobody at all is safe from these kinds of allegations. And individuals from all these different walks of life have been accused of sexual harassment, and some of whom have criminal charges pending or have lost their jobs because of it. So the Me Too movement hasn't necessarily stopped within the confines of the United States. In fact, the Me Too movement has gotten a lot of traction and has actually become a global type of event. There's a picture of a big protest in South Korea where thousands and thousands of individuals actually participated in a Me Too event. And it has really awakened our discussion from not just a national perspective, from a global perspective as well, as to what kinds of mechanisms are there in place to protect individuals from sexual harassment in various countries. So the New York Times ran this article in 2018, and it highlighted the different kinds of protections against sexual harassment in the workplace in these various countries. So you'll see the color coding here. So the first grouping are countries that are highlighted in red, and these countries have no prohibition whatsoever regarding sexual harassment in the workplace. The countries that are in yellow have protections, but they're only protections for harassment against women. So if you work in these countries and you're a man and you're sexually harassed in the workplace, unfortunately, there are no protections for those men. And lastly, the last color-coded group of countries in green, where the United States is, have protections in place for both men and women to prohibit such actions against both of them in the workplace. So this gives you kind of a global perspective as to how sexual harassment is addressed in various countries outside of the United States. So now let's go back to our country, and let's go back to where these laws come from. Why is it that companies throughout the United States have policies that prohibit sexual harassment in the workplace? Well, the laws, the sources of law come from both federal law as well as state law, specifically here in California. So you'll see under federal law, you have Title VII that prohibits discrimination on the basis of sex, and that specifically prohibits sexual harassment as a form of discrimination on the basis of sex. And then in California, we have a specific statute called the California Fair Employment and Housing Act, which is also nicknamed as FEHA. And here it prohibits discrimination, harassment, retaliation on the basis of sex and sexual orientation. So under federal law, the Equal Employment Opportunity Commission has defined sexual harassment as unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. The EEOC has also provided that such actions that constitute sexual harassment when it affects the individual's employment, unreasonably interferes with an individual's performance at work, and creates an intimidating, hostile, or offensive workplace. In California, under the FEHA specifically, the law states that discrimination and harassment is prohibited on the basis of sex and sexual orientation, and it provides examples such as physical harassment, verbal harassment, visual harassment, and sexual favors. So in order for us to really dissect what those elements mean in both federal law and state law, let's take a look at some hypotheticals to get our minds thinking as to what it truly means when we're talking about sexual harassment. Because even though it's certainly in the news and we know the term and we hear about it pretty often, it's not as easy to define when we're talking about very specific, detailed scenarios. So let's take a look at these hypotheticals. First hypothetical here is that we have an assistant who provides shoulder massages to her supervisor. Specifically, this assistant enjoys providing shoulder massages to her supervisor. So she walks over at the end of the workday at around 5:30 and says, "You know what, boss, I think you've had a tough day. I'm going to give you a shoulder massage." And she's not asked to do this, but she does it because she's willing and she's happy to do so. Is this necessarily considered sexual harassment? Well, the answer to this is maybe. And maybe is going to depend upon the details that we uncover in the specific hypothetical. There's a lot of unknowns that we don't know about, right? So for example, is this assistant in fact providing it without being coerced by the supervisor, right? Is this a willing and an actually a welcome conduct, okay, by the assistant? The other flip side of that is, wait a minute, is the supervisor himself feeling sexually harassed by the assistant by getting these shoulder massages? And that is another inquiry we would have to find out whether or not he believes that they are welcome or he just feels forced to accept them because the assistant likes to give them. So these are the kinds of questions we would have to find out to figure out whether or not this behavior is welcomed by either of the individuals that are involved. Because technically, either one could potentially claim that this is harassment in some ways. But let's take a step back for a second. What about individuals who are not this particular assistant or this particular supervisor? What about somebody who's working in that same department? Can they feel that this kind of behavior every day at 5:30 is deemed to be sexual harassment? In fact, as we'll explore later on, third parties can in fact also believe this and feel that this is sexual harassment. Next hypothetical. Take a look at that. A delivery person flirts with the office intern. Delivery person comes a few times a day, drops off packages. It is the job of the office intern to sign for these packages. What if the delivery person is flirting with this particular office intern? Would this be deemed sexual harassment? Well, again, the answer would be it depends, because we would need to know more factual details as to what's involved. Okay, for example, let's start with the first one. Is this welcome conduct by the office intern? Okay, is she actually wanting to engage in it and welcoming the conduct of the flirtation that's happening between her and this delivery person? Has the office intern actually told human resources that, gosh, you know, this delivery person who comes in a few times a day has been making me really uncomfortable by some of the comments he's been making, right? What's been the response of the company regarding those complaints? So again, these are the types of facts we'd have to uncover to figure out whether the interaction between these two people are in fact rising to the level of sexual harassment. But the other reason I wanted to point out this particular fact pattern is because that third parties coming into your workplace or interacting with your employees or interns could actually be creating liability for your company as well. So just because the delivery person is not your employee, it doesn't mean that he or she can't make your employees uncomfortable or harass other people at work. So you have to be cautious as a company to make sure that you protect your employees even from third parties, such as delivery persons, vendors, clients, who may potentially create a hostile work environment or a sexual harassment scenario. Next hypothetical. We have an employee who goes to the office over the weekend to view pornography on a company computer. Well, before we even get to the sexual harassment analysis, this would probably be a violation of your company's computer access, computer policy, that you're not supposed to be looking at such pornographic material on the company system. So on one end, it's probably going to violate your company's policy regarding computer usage. But what about sexual harassment? Is this sexual harassment? Who is this person sexually harassing, right? Well, aside from violating your company policy with computer usage, potentially somebody walking by could be viewing what you're viewing, right? This employee's viewing. Or sometimes individuals move from workstation to workstation, and some other individual could actually inherit that particular computer and inadvertently view certain things. So it could potentially be sexual harassment if it's happening all the time or it's severe enough. And again, we'll talk about those elements in a little bit more. But I just wanted to flag to you, in this world of electronic usage, those kinds of harassing videos or pictures can certainly create what they call a hostile work environment. Next scenario here. We have a text message between coworkers. Coworker is asking another employee out on a date by way of text message. And as you've seen the message, Matt says, "Hey, I'd love to take you out tomorrow if you're available. I was thinking dinner and a movie." Coworker, female coworker, let's assume, responds and says, "Hey, I think you're great. I just don't think the chemistry is right between us." Matt responds, "No worries. I'll see you around." Could this potentially be sexual harassment? And again, I hate to say it over and over again, but it really depends on more additional facts. So right now I'm going to take a quick break because I have a question from one of our audience members regarding this scenario between office romances. The question is, how many times does it take to ask a coworker out on a date for it to be considered sexual harassment? There is no specific magic number that gets you over to the threshold where sexual harassment, bell would be dinging and liability would be ringing. However, what we have to look at is, what are the relationships between these two people, for instance, right? Did the employee who is being asked out say to the other individual that the behavior is not welcome? And that could be a denial of the request on a date. So that's communicating that that person is not interested. And the follow-up question to that is, did that person persist in asking out the individual after it's been made known that the behavior was not welcome? So, one time it's probably not going to get you over that threshold, but if it keeps happening and it's, the other individual keeps saying no to that person, then the behavior starts becoming pervasive, and then it starts to create potentially a hostile work environment if the behavior continues after it's been communicated that it's not welcome. So great question. So, I've thrown out some words out there like hostile work environment and wanted to highlight what exactly that means. So hostile work environment and quid pro quo are two general categories of sexual harassment, okay? So this is what their definitions are. First, let's talk about quid pro quo. So quid pro quo is a demand for sexual favors. It's an unwanted sexual advance which conditions an employment benefit upon exchange of sexual favors. So think about the scenario, for example, of the supervisor who is receiving massages from the assistant. If the supervisor were to communicate to that assistant, "Hey, you know what? I really would like to take you out on a date. I really, want you to give me these massages. And in exchange for that, I'm going to go ahead and give you a really great review. I'm going to give you a promotion. I'm going to give you some type of, company perk because you're providing these types of sexual favors to me, like going out with me, giving me massages, and so forth." If we assume that the assistant does not welcome that behavior, that is a perfect example of what would be deemed quid pro quo sexual harassment, okay? Now, the second type of harassment, which I've mentioned, is called hostile work environment harassment. It's a little bit more broader. So it's defined as unwelcome comments and or conduct based on sex that is so severe or pervasive that they interfere with the employee's work performance and or creates an intimidating, hostile, or offensive work environment. So certainly a lot of words to unpack there, but we'll go through that. We'll go through that in terms of what all those elements are in just a second. So let's go back to the elements of quid pro quo. First element of quid pro quo is employee is subject to unwelcome conduct or advances. So just like in the scenario I gave you with a supervisor who's receiving massages from this assistant, we're going to assume that the assistant does not welcome the request for the massages or the supervisor asking her out on dates. So that would be satisfying the first prong, which is unwelcome conduct. The second is that the employee's reaction or required conduct affects the terms and conditions of employment. So meaning if she succumbs to going out with a supervisor or succumbs to the request to give massages, right, that there's going to be some kind of required conduct that's going to affect the terms and conditions of her employment, such as, like I mentioned, she'll get a raise, she'll get a promotion if she complies with the request. And the last part is that the conduct has to be based on the employee's sex, right? There's some kind of sexual component that's involved in it, okay? So the massages or asking out, going out on a date, those types of conduct would be deemed to have a sexual component involved, okay? So hostile work environment, which is the second category we mentioned, is a little bit different. The action has to be sufficiently severe or pervasive, right, as to alter the conditions of the victim's employment and create an abusive working environment. So think of it a little bit more broadly, okay? Think of not just the massage situation, but think of a situation that involves individuals who are viewing pornography on the company website and another coworker having to view that over and over again because they're sitting in the cubicle right behind that individual. So that could be severe and pervasive, right? If they're seeing it all the time, and that coworker can complain, gosh, you know, me having to sit behind this guy who's always watching pornography on the company website, company computer, is really creating an abusive working environment for me, and it's making me very uncomfortable to have to sit here and do my work in light of what I'm viewing right in front of me. And again, we have the prong of subjectively and objectively unwelcome, meaning we have to take a look at the conduct and assess whether or not the individual who is receiving the conduct actually does not welcome it, and whether a reasonable person in that employee's position would consider that conduct to be unwelcome. And the last prong, which both of the categories share, is that the behavior has to be linked to some type of sex or gender, some type of sexual component. Okay. Hostile work environment, as I mentioned, is pretty broad. So it's going to encompass verbal harassment like comments, derogatory comments, or slurs. It could also encompass physical behavior such as assault, impeding or blocking movement, or any physical interference with a normal work or movement when directed by an individual. The example I gave you with Matt Lauer, where he was able to press a button underneath his desk and the office doors would lock, basically locking the person in there with him, would be an example of impeding or blocking the person from leaving the office, okay? Another example of potentially an element of hostile work environment harassment is visual harassment. So derogatory posters, cartoons, drawings, videos, pictures in the workplace that could affect the workplace of other individuals in an abusive way. Okay, so these are just other examples. We're talking about jokes, offensive comments, statements, gestures, pictures, touching, leering, any of the above. Okay, so those are kind of broad strokes as what the definitions are of both quid pro quo harassment and hostile work environment. Okay, this next case I wanted to highlight is called Miller versus the Department of Corrections. And this goes towards third-party romances and potential liability for acts of sexual favoritism. In this particular case, Miller involved a jail warden in California who was involved with consensual relationships with multiple female staffers at this particular jail facility. Okay, so everything was fine. He was dating several female staffers at the jail, and there was no complaints between him and the people that he dated. However, third parties who were not involved in those consensual relationships actually filed a lawsuit claiming that they were subjected to a hostile work environment because they were not provided with particular perks because they were not engaging in relationships with the jail warden. And that case went all the way up to the California Supreme Court. And the court basically stated that there could be liability for consensual relationship based on a claim of favoritism by other employees. Specifically, the Supreme Court of California highlighted that when such sexual favoritism in the workplace is sufficiently widespread, it may create an actionable hostile work environment in which the demeaning message is conveyed to female employees that they are viewed by management as sexual playthings, or that the way required for a woman to get ahead in the workplace is engaging in sexual conduct with their supervisors or management. Okay, so this was an important case because it really took a look at how third parties who are not even involved in the relationship could potentially be affected. I'm going to take a quick pause here and take a look at a question that's been provided to us by our audience. The question is, what can a company do to protect itself from claims made by third parties who are not involved in consensual relationships in the workplace? Okay, that's a great question. So many companies, what they've done to protect themselves is to have policies regarding office romances. So anti-fraternization policies. Okay, what that means is that they prohibit relationships, romantic relationships, for instance, between a supervisor and a subordinate, so that, number one, that there is no type of quid pro quo situation that could go on between those two individuals, but also from a broader perspective, they want to make sure that other third parties who are potentially reporting to that particular supervisor don't feel that there's some type of sexual favoritism that is going on because they are not engaged in that particular relationship with the supervisor, and that the individual whom the supervisor is dating is receiving some type of perk. So that's something the company could do to actually protect its employees as well as the company itself from any claims of sexual favoritism with dealing with third parties, as well as any quid pro quo claims that could be raised by the individuals that are involved. Great question. The other case that I want to highlight with regards to hostile work environment is the case called Lyle versus Warner Brothers NBC. This particular case involved the show Friends, which was very popular in the 1990s, and basically a group of assistants of the writers for the show Friends filed a lawsuit claiming hostile work environment harassment when they were forced to be part of meetings amongst the writers in which the writers would discuss a variety of different stories, some of which were personal for the writers, and some of these discussions would involve, things of a sexual nature, relationships that maybe some of the writers were having with other folks outside of the workplace, what they've done over the weekend, and it had sexual discussions. So they felt that, why do I have to sit in these meetings and be subjected to these kinds of discussions, and we feel like it's a hostile work environment? Well, that case actually went up to the California Supreme Court as well. And in that case, the Supreme Court provided that, the Supreme Court provided that that is actually part of the assistant's job is to participate in those kinds of discussions, and that the discussions of a sexual nature that were being had by the writers in fact translated to some of the episodes that were found on Friends. So it was part of their job, and that it was part of the creative process specifically of the writers, and it did not create a hostile work environment for those individuals that are involved. So I think that's an important case to highlight, because sometimes there's tension between hostile work environment and places that are of a creative nature. Like, where do you draw the line between the kinds of behavior that could be deemed creative and types of behavior that could be deemed harassing? So now let's take a step back and let's see if we've learned anything from our discussion so far. Let's answer some true and false questions. First, a hostile work environment harassment claim does not need to involve physical conduct. As we've discussed in earlier slides, a hostile work environment claim certainly does not need to involve physical conduct. It could be impeding or blocking movement. It could be showing pictures or drawings or videos. So the answer to that is true. That is in fact a true statement. Next statement, only a company can be held liable for damages resulting from a sexual harassment judgment. And the answer to that is false. In fact, anyone could be held liable for their own acts with regards to sexual harassment. So a supervisor could be held liable, an employee without any type of supervisory duties, and the company could also be held liable. So each and every one of us could be potentially held liable for our own actions. Next, the FEHA is the federal law prohibiting sexual harassment in the workplace. And the answer to that is false. The FEHA is actually the state law in California that prohibits sexual harassment in the workplace, when it stands for Fair Employment and Housing Act. Next question. In order to prevail, a complainant must show that the harassing conduct was unwelcome. So the short answer to that is true, right? So for both quid pro quo as well as hostile work environment, the complainant has to show that he or she did not welcome the conduct that they were subjected to. The last statement, quid pro quo harassment occurs when an employee suffers negative consequences for reporting sexual harassment. That definition of quid pro quo is in fact false, and that definition is actually the definition of retaliation, which is our next slide. So under both federal and California law, it is prohibited to retaliate against applicants as well as employees, those who've engaged in protected activities. So what does that mean, protected activities? Well, retaliation occurs when an employee suffers a negative consequence after the employee reports sexual harassment, files a complaint, assists someone else in filing a complaint, or participates in a discrimination or harassment prevention activity. What that means is, if you come forward with a sexual harassment complaint, the employer is prohibited from discriminating or harassing or retaliating against you because you provided and come forward with that complaint. Also, other individuals who are participating, such as witnesses who are interviewed in that process, are also protected against retaliation. And adverse actions that could potentially be involved in retaliation claims could be anything from termination, demotion, suspension, denial of a promotion, poor evaluation, or an unfavorable job assignment. Harassment is also not limited to a man or a woman. It could be same-sex harassment, where you have men sexually harassing other men, women sexually harassing other women. Sexual orientation in and of itself is not relevant, and sexual desire is not required. What do I mean by that? Is that in some circumstances, like quid pro quo, perhaps sexual desire is present in those scenarios where a supervisor is asking an individual out. But what about scenarios where an employee continues to view pornography on the company computer system and the individual sitting right behind them is viewing pornography because of that particular individual. There's no necessarily sexual desire between those two individuals. It's just that the individual viewing the pornography has created a hostile work environment for others, including the person sitting behind them. And the last part is the key element in terms of harassing conduct. You could have to, again, have some kind of sexual component involved in the behavior. But what about other forms of harassment? We've already talked about in pretty good detail what sexual harassment involves and the elements that are involved in it. But what about the other categories I mentioned at the very first slide? One of which is gender, gender identity, and gender expression. How does that fit into our discussion today? Well, both California and federal law, as I've stated, also prohibits discrimination and harassment based on these categories. It protects, for instance, the right to appear or dress consistently with one's gender identity or gender expression. It now requires, under California law, for an employer to use an employee's preferred gender, name, or pronoun. And it also protects both applicants, independent contractors, unpaid interns, and volunteers from harassment or discrimination on the basis of gender, gender identity, and gender expression. So I'm throwing out a lot of big words out here. What am I talking about when I talk about gender expression or gender identity? So I've listed for you on this slide the specific definition in a very broad and generalized way what gender expression is. So let's take a look at what that is. Gender expression is a person's gender-related appearance or behavior, whether or not stereotypically associated with a person's assigned sex at birth. And gender identity could be defined as each person's internal understanding of their gender, which may or may include male, female, a combination of male and female, neither male or female, a gender different from the person's sex assigned at birth, or transgender. So I would simply look at this in a very broad way. Your gender identity is the gender that you identify with internally. And the expression is how you express to the world what that gender identity is. For instance, I identify as a woman, so I express to the world that I'm a woman in the way I wear my hair, in the way I speak, in the clothes I wear, in the jewelry I wear, in the makeup I wear. So that is an expression of what I internally feel as my gender identity. Also, other definitions. Transgender, a general term that refers to a person whose gender may be different from the sex assigned to that individual at birth. A transgender person may or may not have a gender expression that is different from the social expectations assigned sex at birth. An individual who is transitioning, for instance, is a process that some transgender people go through to begin living as a gender which they identify with, rather than the sex that they were assigned to at birth. So think about one of the most high-profile transgender individuals who have transitioned would be Bruce Jenner, who's transitioned to Caitlyn Jenner. I'm going to take a quick pause for a second and get another question from our audience member. The question is, what should a company do if a male employee who is transitioning to a female wants to use the female restroom, but other female employees in the company are made uncomfortable by this request? That is a good question, and actually we've heard that from quite a few of our own clients. So it's pretty settled law in California that the uncomfortableness, for instance, of the other female employees are not going to trump the rights of the individual who's transitioning to use the bathroom of his or her choice. So in a scenario like this, if an individual is transitioning and feels that they're now, for example, transitioning from male to female, that individual should have the right to use the bathroom of their choice, which is, in that specific scenario, the female restroom. And it's going to be incumbent upon the company to have an open and honest dialogue with all its employees to make sure that everyone is made comfortable and that the rights of everybody is protected. So now let's go forward with how these claims can arise. We can see that you can have a variety of different types of numerical combinations. You get one employee versus several employees versus one employee, and so forth. Okay, you have a subordinate and supervisor. And who can be liable for these damages? As we've discussed earlier, a company could be held liable for sexual harassment, sexual harassment claims if a manager or supervisor acted inappropriately, or if a company knew or should have known about a coworker or third-party misconduct and failed to do anything about it. A supervisor and any coworker can be held liable for their own acts. Okay? Well, what are the remedies for harassment in terms of a litigation, right? Well, you can have actual damages that could be awarded by the jury. So that would be like lost wages, lost benefits, medical expenses, property damage. You can also have general damages such as emotional distress if the jury finds that the plaintiff had emotional distress. And you can have punitive damages, which is another layer of damages that a jury can impose to really punish the defendant or defendants for the bad acts they've committed if they've found liability. And lastly, a defendant could be liable for the attorney fees that the plaintiff has incurred. Okay. Now in the last 10-15 minutes of our discussion, what we're going to do is cast our net a little more broadly in terms of workplace bullying. Okay? At the very beginning of our discussion, I mentioned to you that there is abusive conduct in the workplace that could be deemed to be unlawful if it is done based on one of the protected categories we talked about. So first, what is this abusive conduct I'm talking about? Well, abusive conduct means conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests. Abusive conduct may include repeated infliction of verbal abuse, such as use of derogatory remarks, insults, epithets, verbal or physical conduct that a reasonable person would find threatening, intimidating, humiliating, or gratuitous sabotage or undermining of a person's work performance. So no single act necessarily constitutes abusive conduct unless it is severe and egregious. Okay? So that's the general definition of abusive conduct in the workplace. But in order for abusive conduct to actually be actionable, unlawful, I should say, it has to be tied to a protected category. So again, let's take a look back at the very first slide in which I've highlighted some of these protected categories. So when I'm talking about abusive conduct, let's for example say there is a supervisor who yells and screams and belittles a group or an individual based on one of these specific categories. So let's say the supervisor is yelling at an individual or individuals because that person is, for example, a part of a particular race or part of a particular religion, then that abusive conduct would then be deemed unlawful. So we need to prevent abusive conduct and to avoid not only creating a poor morale in the workforce, but also to prevent any kind of potential violence that may arise because of that abusive conduct. So what we have to do, and it's incumbent upon each and every one of us as employees, to really improve communications between management and employees. So management's role is to really have a good relationship with the employees and to communicate their expectations, and vice versa. The employees must do the same thing, but you have to do this in a professional manner. Other things, you have to increase awareness by managers, supervisors, and employees of warning signs of workplace bullying or abusive conduct and violence. So managers as well as non-managers really have to identify and be, on the lookout for individuals who are exhibiting signs of those kinds of abusive conduct, especially that if it's targeting specific categories that we've mentioned, and it has to be reported and dealt with. So we have to provide counseling, the company does, to managers, supervisors, or employees who exhibit strain or pressure that could lead to that kind of verbal, physical violence. Counseling could be anything from, a human resources individual having a discussion with those individuals, or sometimes when the behavior is so egregious, there's times where the individual has to take time off of work and that they actually have to take a leave of absence to take medical counseling or medical help to actually help them get through whatever behavior that they are exhibiting. Other things we have to remember is that it is incumbent on every individual to monitor and respond to belligerent, intimidating, or threatening employee behavior. So if you yourself are receiving it, or you are witnessing other people in the workplace actually engaging in this kind of behavior, it is your duty to actually report that to management or whatever designated human resources person so that behavior is in fact dealt with. We have to ensure that acts of bullying, threats, or acts of violence are immediately reported and responded to. And the company will have the responsibility to investigate, and if there is behavior that was inappropriate, the employee has to be disciplined, and potentially there could be reprimand or all the way to termination depending on the egregiousness of the behavior. So what are these early potential warning signs? Well, verbal threats, intimidating behavior, bizarre thoughts, paranoid behavior, obsessions, recent marked performance decline, serious stress in an employee's personal life, and potentially substance abuse. And these are just a few examples of what you guys have to look out for in terms of early warning signs of potential workplace violence, because it is in everybody's best interest to make sure that you create a safe working environment for your workplace and avoid any kind of potential workplace violence situation. So, in a nutshell, I know I've been talking for a long time and there's been a lot of information provided to you, but what I really want you guys to walk away from is this, that each and every one of us could be a potential bully or harasser, and we have responsibilities to prevent ourselves from being a potential bully or harasser. And what are our responsibilities? We have to pay attention and receive the message being sent, and we have to respect the boundary being set. What do I mean by that? Let's say an individual coworker comes up to me and says, "Gosh, Michelle, I don't know if you noticed this, but you come up and you rub my shoulder, or you're very touchy-feely every time you come up and talk to me. And perhaps I, as an employee, aren't even, aware of what I'm doing." So what I have to do is I got to receive that message that is being communicated to me by the coworker, and I have to respect the boundary that that individual has provided. So I have to change my behavior. And the last part of that is I can't retaliate or ignore because that individual has raised an issue with me. Okay? So that is your responsibility, each and every one of our responsibility as a potential alleged bully or harasser. The flip side of that is any one of us could also be a potential victim of harassment or bullying. So our responsibility on that note would be to communicate the boundaries, either directly or indirectly, and to get help from within the company. So if I'm being made uncomfortable by something that a coworker is doing, what I have to do is communicate my boundary to that individual and address it with them. If that is too much, it's too difficult of a discussion for me to have, then what I have to do is seek out other people in the company who could intervene. That could be my supervisor, any member of management, a designated human resources person, and it is the company's responsibility to actually do something about that, to address it, to investigate, and to circle back and address the complaint that's been made. So in a nutshell, we're having this discussion today for your benefit as well as the company's benefit, because the employer has now taken the responsibility by creating a policy for you guys, which is found in your handbook, also to provide you with this training, which is required under California law. And the last part of that component is if there's any complaints made regarding bullying, harassment, that employer is going to also be investigating any kinds of complaints made. So thank you very much for participating in today's discussion. I really appreciate the questions. And if there's any questions that I was not able to get to, please send me an email and I'll respond after the session. Thank you very much.